There are some jurisdictional and preliminary considerations for all child custody cases. Nevada adopted the newer Uniform Child Custody Jurisdiction and Enforcement Act to replace the old UCCJA, effective in October of 2003. It introduces and refines the concepts of a child's home state, meaning where the child has lived for 6 months before an action was initiated. If this is the child's home state, then it's presumed that Nevada will have child custody jurisdiction here. If this is not the child's home state, then there are secondary considerations that might be applicable, but they're too fact-specific to be gone into here, and those are the sorts of things that ought to be discussed in a consultation. Matters of custody and visitation are never really finished during the minority of children. Theoretically, they can be changed whenever there is a change of circumstances, under the standards that we're going to discuss in a little while here. However, anyone dealing with child custody matters should understand that there's a certain matter of inertia to any child custody determination. And once a child custody determination is made, sometimes even a temporary custody determination, it tends to remain in effect, at least throughout the case, and possibly for the duration of the minority of the child. Custody comes in two flavors, legal and physical. Legal custody defines who's a parent, who has rights and responsibilities relating to that child, who can decide whether the child can marry at the age of 16 or enter the army early, or who decides what religion the child gets brought up in, etc. In Nevada, realistically, legal custody, is almost always joint, unless there's some reason to deprive one parent or another of decision-making capabilities relating to that child. There is no statutory definition of legal custody in the Nevada statutes. That makes it possible to specify and to alter from case to case the specific rights and duties that are allocable between the two parties forming joint custody.